Welcome to another edition of Inside Rosenberg and Estes. I'm Dave Lorenzo, and we're here today with Bill Byers, and we're talking about a specific subject. Today, we're talking about the Corporate Transparency Act. And the reason that I wanted to have Bill come on and talk about this is because there's a little bit of ambiguity. So we're going to start with having Bill describe what the Corporate Transparency Act is first, and then we're going to get into why it's been in the news lately. So, Bill, tell us first, what is the Corporate Transparency Act?
Okay, the Corporate Transparency Act was enacted to fight against money laundering, fight against other illicit activities, and to help kind of reveal bad actors hiding behind shell companies. That is the main purpose of them wanting the disclosure of the beneficial owners and controllers of companies.
So what they're asking business owners to do is to go on a website and register, right? Explain what the act itself asks people to do.
Right. So they want any company that is formed during 2024 within 90 days has to report their beneficial owners. Benefit to FinCEN, the agency that's regulating this. They have to report anybody who owns 25% or more of ownership interest in the entity. They also have to report anybody who has substantial control. Substantial control is very broad. It includes senior officers. It includes people who have enough voting equity to control the company. It could include certain board of directors, and it just reaches very vastly, and it's hard to kind of determine sometimes, but you have to go through your corporate tree and see who has what type of control.
So if you currently have an LLC, if you have a business that's a corporation, whether it's an S Corp or a C Corp, if you have a partnership, all of those types of businesses have to go on the FinCEN website. We'll put the link down in the show notes, and you have to disclose who the owners of each of those entities is. Even if you set up a special purpose entity for buying real estate, whatever the entity is, if it's a registered entity, you have to disclose who the ownership is. Now, Bill, there are certain exceptions to this, and we can get into what the exceptions are. But before we do that, a couple of months ago, as we're recording this in May, a couple of months ago, there was a court case, and the court case stayed the need for certain people to file the beneficial owners. Explain to folks what that court case did and who is affected by it and who's not, please.
That court case enjoined the FinCEN from enforcing the CTA against the plaintiffs in that case. They did not decide the case on the merits of whether certain amendments were violated. They decided it on certain powers that Congress had, one of which was the foreign affairs power. And the government argued that these reports were necessary to protect national security against anti-money laundering, financing of terrorism, and other illicit activity. The court said the powers do not extend to purely internal affairs like corporate formation. And that's because that's typically left to the states to do. And here, the entities that are captured by this Corporate Transparency Act that have to regulate with it are entities that have to file their formation documents with a state Secretary of State or an Indian tribe's similar office. So they're saying this is really states' purview. They next move to the Commerce Clause, and that deals with the channels of interstate and foreign commerce. And they decided again that the act of corporate incorporation alone is not enough to invoke the Commerce Clause. So the plain text of the Corporate Transparency Act itself does not discuss interstate or foreign transactions. They again shut it down on that. But here is where it got interesting, because the court here made it very clear that they felt that Congress knew how to draft this. Congress knew how to put in some type of jurisdictional hook to get this to be constitutional and get this information for themselves. So they actually, to some degree, told Congress or told FinCEN, the regulators can do it too from a regulatory standpoint, how to fix this, but they weren't doing it in the ruling. So they permanently enjoined FinCEN from going after the plaintiffs in that case. The rest of the companies out there are still subject to it.
So unless you were part of the National Small Business Association, that was the plaintiff. Unless you're part of the National Small Business Association, or you were part of it at the time of that court ruling, you still have to file the beneficial owner information on the website so that you can be in compliance with the Corporate Transparency Act. So it still applies to 99.5% of all the companies that are out there. So if you're listening to this and you have an LLC, or you have an S Corp or a C Corp or a limited liability partnership or any type of corporate entity, you have to disclose the beneficial owner information to FinCEN. And as Bill said, the reasoning for this is to supposedly protect us from money laundering and for national security purposes. Now, Bill, what are the guidelines? What are the parameters? What's the time frame for filing this information? So let's start by saying that I have a company that's been operating for years. How long do I have before I have to go onto the website and file this information?
Any company that was formed prior to January 1 of 2024 has until January 1, 2025 to file this.
Okay.
Depending on the company and depending on how many entities they have, that could be an easy thing for them to do, or they should probably be preparing for it. We have clients who have hundreds of companies, and they're going through it now because it's a big lift to figure out who all the owners are, who truly has control. And depending on the client, sometimes they don't hear from these shareholders or interest holders for years at a time, and those people are reluctant to provide the information that they need to file. It's a time-consuming effort to try to get all this information.
So as of now, as of the time of us recording this, everybody, unless they're part of the National Small Business Association or were part of it at the time of that court ruling, you've got to disclose. So if you're like the commercial developers that you work with, Bill, they have hundreds of special purpose entities with maybe 3 or 4 or a dozen investors each as a part of them. They have to go on there, and the information that is asked for is what? It's like the name, address, like what do you have to disclose?
It's pretty basic information. It's the name, it's the address. They need to provide some type of government-issued ID confirming that information. They can apply for what's called a FinCEN identifier, because each time you submit this information, obviously there's a possibility that it could get out there, that it's not as secure as people think. So you can actually apply for what they call a FinCEN identifier. So for somebody who has 100 entities, say, they can just give the number each time, as opposed to transmitting their address, their name, their government credentials every single time with every single filing.
Now, Bill, that's an advantage of having you do this for them, right? So if you do this for them, they give you their ID, and then you go in there and you apply for the FinCEN identifier, and then you update all their filings for all their entities with that FinCEN identifier, so they don't have to worry about it.
Right. That's certainly a service that we can provide.
Yeah, I mean, to me, it makes sense if I'm a developer and I have 30 or 50 or 130 or 1,500 different entities. I'd rather have somebody who does this all day, every day, prepare the FinCEN identifier application, get the number, and then just go put it in over and over and over again. To me, that seems to make the most sense. So let's talk now a little bit about what they need to do in order to define who a beneficial owner is. What are the parameters? What are the guidelines for defining who a beneficial owner is?
It's a two-part process. There's two possible groups of people that could be beneficial owners. One is an owner that has 25% or more of the interest in the company. Those could be springing interests as well. So somebody who doesn't have their interest right now, but could come up in the future, like an option for interest. And then you have people who have substantial control. And it's substantial control that is very broad, where you get, who has a lot of reach, and it's intentional that way. They want to know who's controlling the entity. Those could be the same people who have the 25% or more interest. It could be your senior officers, such as chief executive, chief operating officer, general counsel. It could also be anybody who doesn't have that title, but actually has control of the business, even without ownership interests. And it can go to board members.
Wow, even board members. Okay.
Your everyday employee would not be typically trapped by something like that.
Okay. So if we're looking at this, how do we know which industries or what types of companies are exempt? How can we find that out?
There's a list of 23 types of entities that are exempt. Most of them are highly regulated entities to begin with. You're talking about banks, public companies, public stock companies. One of the ones that is helpful sometimes is the large operating company. That's a company that makes about 5 million in gross a year, I believe. It has 20 full-time employees employed by that entity, and it's all within the United States. What's interesting here too, and that we've run across, is you have affiliated company, not even a parent company, an affiliated company that has all the employees that works for the other entities, but the other entities are where all the money's coming in, and then you don't get the exemption. So it gets a little complicated. They also look at subsidiaries of large operating companies, and there's inactive companies. Companies have been in existence before 2020, but are sitting around with no real assets and take in or send out less than $1,000, a year. So that also is a way. You're right. They're literally not doing anything, right? So, and people have a lot of these companies sitting on the shelf. So those are the ones we found are useful so far, closing out old companies.
Yeah, so if you're wondering whether your business is exempt from this, there's two things you can do. You can go on the website. Again, we're going to put a link down in the show notes. You can go on the website and look, or you can call Bill, and Bill can look into it for you and see if you're exempt. So Bill, what are the penalties if I don't do this? So I'm a brand new company. If I don't do this within the 90 days, or if I'm an existing company and I don't do this in 2024, what are the penalties? What could happen?
There's both civil and criminal penalties. So the civil end, it's $500 a day until you file the report. Criminal end, it's up to 2 years in jail, plus, and or a $10,000 fine. And
Wow.
if you report, if you report inaccuracies and don't update it, or you report false information, there's other civil and criminal penalties too, which they have not really enumerated.
So if there's a change of a beneficial owner, somebody dies, you sell your interest, does the same deadline apply? Is it the 90-day deadline that applies to go and update it?
Updates are 30 days.
Updates are 30 days.
Right.
Okay.
And on that point, just as a clarification, after 2024, all these reports will be due within 30 days of filing your formation documents.
So it's just like, I think in most states, your driver's license. If you move, like I know in New York State and I know in Florida, if you move, you have to update your driver's license in
Right.
30 days. That's you should go by that rule of thumb for the Corporate Transparency Act too.
Right.
Then, Bill, is this the kind of thing where there's going to be like an audit, and do you think you're going to get a notice, or is this just gonna appear out of the blue? Like, what are the mechanisms that will tell people that they're in compliance or they're not in compliance?
I mean, they all know if they're in compliance. How FinCEN's going to track that and be able to determine if somebody has filed or not is yet to be seen. Obviously, if somebody is out there and they know that they're operating out there, then they know they owe them a report. There's a lot of entities, there's a lot of small business owners that probably don't even know this rule exists. So we have yet to see how FinCEN's going to regulate it from that standpoint and watch who's filing and who's not filing. And we get that question a lot. And the answer is they may never, or they may not for a while. They may only be tracking people that they already think are doing something wrong and looking for the information, but we don't know yet. It'll be a determination of what resources they have and who they're going after.
Bill, what if I buy my assets in a trust, right? So
Yeah.
the Lorenzo family trust invests in an LLC, and Dave Lorenzo and Joe Smith are the managing. Well, no, it's the Lorenzo family trust, and Joe Smith are the members of that LLC. Do we then have to wind back who are the beneficiaries? Is it the beneficiaries of the trust that we have to put on there? How do we do that?
It's a very good question. Let's start with the general rule of you're always going back to a human. You're going back to an individual. That's who the beneficial owners will always be. It's not an entity that controls. It's going back to the people, the people who have the utmost, the final control of that entity. And as far as trust goes, it could be, depending on how the trust is structured, It could be the trustee, if he has the power to dispose of the assets and make the decisions. It could be the beneficiary if they do. It could be the grantor of the trust if it's irrevocable or they otherwise have the ability to make decisions. One thing that comes up with that too are minors. Minors get a special role in this anyway, because minors' parents are the ones who have to report for them. But a lot of times you'll have a trust where a minor is the beneficiary, but they're not getting any powers or any money or anything until they're, say, 25. Well, until that, what we have seen to date, and again, all of this is brand new, but we've seen to date, those minors or the beneficiaries that are not entitled to anything yet aren't the ones with control. And then it would likely be the trustee and possibly the grantor if they have any remaining powers over the trust.
All right. Now I'm going to give you another scenario. And this actually applies to me, and I'm sure it applies to a lot of people out there. So my company is an LLC, but it's owned by two separate LLCs. Okay. You said it has to go back to a human. So do we have to go back an additional generation and report? And then we report this LLC is owned by LLC A and B, and then LLC A is owned by Joe Smith and Pete Jones, and B is owned by, Sally and Jane. So we have to go back as many generations as necessary to get to a human?
Yes. And it's for every entity in that chain. So if you have parent company, and then you have subs A and B, and then sub-subs C, D, E, F, whatever it is, you have to report for every single entity in that chain, and you have to find the individual that at the end of the day is who has control going up through the chain.
So main LLC has two LLCs that own it. Right. On that main LLC reporting is the main LLC, the two sub LLCs, and then the owners of those sub LLCs. Okay. And then the sub LLC has the two owners, and the other sub LLC, these are all separate filings, or the first one is one filing and then there's separate filings for each other one?
It's a separate filing for each entity.
Okay.
And depending on, you have to go through the analysis of it. Let's say it's parent company with sub A and B. Mm-hmm. You have to decide, well, do sub A and B each have 25% or more? And if they have 25%, if they don't, it stops there. If they do, it stops there for the determination of who has a certain percentage interest. If it does have 25% or more, then you have to go down from there and determine who has 25%, or you keep going down to find out who really has the control, the ownership prong going up. And at all times, you have to figure out who has control there.
Does it make sense to, I'm thinking to myself, right? For my own purposes, probably each year when I file my taxes, I'm going to want to go in and update this thing just so that I have a deadline to follow, right? Is that how are you counseling your clients that they what date do they put on the calendar? Because does it depend on when they file now? How do they keep track of this?
Well, anytime there's a change, they have to update it, and they have to update it within 30 days of the change itself. But as far as corporate responsibility and good practice, I would think that the year end probably is the right time, or a time in the year when you are going through that type of information anyway. This should be added to the checklist of, hey, have we had any more changes? Do we have to update FinCEN and let them know?
All right, now let's talk about the purchase or a sale, right? So we do an asset purchase, or even a stock purchase of a company. As a transactional lawyer, you're on the side of the seller. Whose responsibility is it to update? You would say it's the buyer's responsibility, right?
If they're buying the entity itself,
yeah,
I would say it's the buyer has to give their new information. If I was advising the seller, I would say I want this information at closing, because you want to make sure that you're taken off.
Right.
And you want to make sure that they update it. You don't want FinCEN coming to look at you because they heard there's a change and you having to explain what changed.
So for those of you who are watching this or listening to this, if you're looking at your closing checklist and it does not include updating the Corporate Transparency Act, you need to add another line on your closing checklist: check or update the Corporate Transparency Act. If you're borrowing money, Bill, is this something that there's no requirement for a bank to check to see that the corporate
The bank
transparent?
needs, I believe there's regulations that the banks need to know their customers.
All right, now let's talk about people who, for lack of a better term, a term of art, like to get cute, right? I work with family offices, and one of the questions that they've asked, and I don't know the answer, so I'm going to ask you, is okay. Let's say I set up a foreign entity. I set up a company in Bermuda, and the company in Bermuda owns the U.S. company. What is the responsibility of the foreign entity? Like, is it good enough for us just to put the foreign entity, or do we have to figure out how to go back to a human in the foreign country?
You have to figure out how to go back to a human as well. And if that foreign company used their own company and applied for authority to do business in the States, they would be subject to the same regulations.
Wow. Okay.
One of the things I wanted to mention too is that what we're doing now is we're adding provisions to the operating agreements to help the companies have an ability to force a member to give information, because members can be reluctant to give this information. They don't understand it. They think they're throwing themselves out to the feds to get investigated. That's not really the intent, unless they're doing something bad.
Has the federal government provided any assurances for privacy purposes that this list won't be sold, or this list is not subject to a Freedom of Information Act disclosure, right? Like what assurances has the federal government provided that this information is not going to be readily available to marketers or people who want to, do nefarious things?
Well, this information is to be maintained as on a non-public database. It's only to be available to law enforcement agencies, certain other government agencies, and financial institutions. So it should not be getting out. It should not be foilable by the average Joe. It's not supposed to get out to the public. And interestingly, and a side note, which we'll get into another day, New York just enacted their law, and the governor made them go back and make it similar to the CTA, where it's going to be a non-public database as well, whereas the state legislature originally wanted it to be public to some degree.
Interesting. All right. So we talked about when you have to file. We talked about what information you have to put in. We talked about the reasons why this is happening. What if people just decide they're going to enter false or misleading information in there, right? Are the penalties for that the same as the penalties for non-filing, or are they more serious?
They did not enumerate what those penalties would be, but it's civil and criminal penalties again.
Yeah.
And it will go down to the individual if they're the ones providing that information.
And the person responsible is ultimately the owner of the business. It's not the, if you assign this to, a clerk in your company and the clerk screws it up, the owner of the business is held accountable, correct?
Right, unless the clerk knew they were falsely providing false information. Yes, right. It's the source of the information, and the company is the one who has to file, and the company is responsible.
Is there a cost associated with filing this?
There's no fee for FinCEN's filing itself. A lot of people are using service companies to help file these because they have databases and they have the means to get these things filed quickly and easily and correctly. And that those fees are, we have a contract with corporate services company, and we pay $175 for our clients' filings, and if a client wants to do something more direct with them, it's a $250, I believe.
Yeah, it makes sense to have some. If you have multiple entities, I think it makes sense to get that number. What's that number called again?
The FinCEN identifier.
So it makes sense to get a FinCEN identifier, right, if you have multiple entities. And then your information is in their database, but all of your entities just have that FinCEN identifier.
Right.
I think if you have multiple entities, that's absolutely the way to go.
Yeah.
When you talk to your clients now, what are the biggest things that are coming up about this? What are they most concerned about?
Well, they're concerned about the privacy and why do they have to disclose this information? And you have new companies that are out there forming, and they have investors coming in. The investors haven't decided what form of entity they're going to come in with, or the name of the entity, or possibly how much they're going to invest. And it makes it complicated at the beginning of the transaction that way. But the bottom line is the biggest pushback is always, why do I have to provide this information? What am I exposing myself to? And the answer is you have to, because it's required by law. And FinCEN's been pretty clear that despite that ruling that we discussed early on, that they are going to enforce this, and all entities have to provide the information.
Terminated entity. A business goes out of business. There's no reporting there, right? It just the entity, once the entity ceases operations, it still stays in the database, and you don't have to do anything.
For an example, if the entity was in existence this year, and then they stopped doing business or they dissolved, they'd still have to report for this year. But no, and that I think that would fall under what they would call the inactive entity. That you've got an entity that's not there, and you do not, under the CTA, have to file that.
All right, Bill, what else do people need to know?
They need to know that it takes a little bit to get this information together. That if they've got if they have a corporation with a complex structure, such as with trusts or many shareholders, it's important to get a head start on it. If they're a company that has hundreds of entities or tens of entities, even, this process takes a little bit, and they should start organizing that information. They should start discussing with us or their other lawyer, what information they need. How do they get it filed? What's the best way to do this? They should be ready to comply with it. I don't think it's going away.
Yeah, I don't think it's going away either. I think there may be some challenges to it. It may be modified, but unless you're part of the plaintiffs in that case, you got to do this. So, and if you don't know if you're a plaintiff in that case, you're not a plaintiff in that case. You're going to need to do this.
Exactly.
Hey, how can people reach out to you to get more information, or if they need help on this?
Well, I mean, they can call me directly. They can send me an email. We can talk about it. I'm fielding questions constantly from friends, colleagues, clients, almost everybody you know is going to have to comply with this. And I'm happy to chat with people and try to get them the information they need to get started. And then we can, of course, help them out. As I mentioned earlier, we're helping a client out who has, I believe, 275 entities. And it takes a little while. And we're helping them walk through it. And any complexities we're clearly able to assist with. It's really only the very simple ones that wouldn't need some type of, guidance.
Yeah, that 275 entity client, FinCEN has a FinCEN identifier, I would imagine, and you're just dropping those in there.
They were just obtained.
Yeah, right. Perfect.
Because again, in that instance, you have the control people are a handful of people throughout the entire organization. So it makes sense.
Sure. All right, folks, if you want to reach out to Bill, he's going to give you his phone number right now. Bill, your phone number is?
212-551-8456.
Okay. And if they want to email you, we'll put the email down in the show notes. But what's your email?
It's WBYERS@rosenbergestes.com.
All right, so this has been the show on the Corporate Transparency Act. It's everything you need to know. And what you need to know is it probably applies to you, and you probably need to file, and you probably don't have a lot of time left. So if you need information on this, reach out to Bill. He's given you his information. We also have the information in the show notes, and we have a link to the government website with all the exempt entities so that you can see as you scroll down, you're probably not exempt and you probably need to do this. So reach out to Bill today. This has been Inside Rosenberg and Estes. I'm Dave Lorenzo. We'll see you back here again next time.